The chairman posits that he was early in the morning when he wrote through his affidavit, visited by a number of individuals, some of whom comprised politicians and some of whom were various eminent persons in the country, and that their intention was not to enhance the credibility of what he was doing. But he tries to conflate this with the visit of the NCAC by saying, connecting it to what had happened that night, that further, that at 10 a.m. in the morning he was informed by Professor Goulier that the team from NLCA had arrived at the Tallying Center, and he later learned that they had proceeded to the office of Deputy Inspector General of Police. Nothing could have been true than the fact that he was rang by Mr. Kinyua, who told him that because of security concern and tension which was arising in the country, arising out of non-transmission, and of course we have had an example on this in previous election, he was sending a team to go and visit him and discuss the issue of security. That notwithstanding, the chairman pretends that this was an issue which he only came to know when he was informed by Professor Goulier. But immediately thereafter, he concedes that he was rang by Mr. Kinyua, but pretends that the call was by Mr. Kinyua to tell him that the team was coming to discuss the succession procedure, which is a matter which, to his knowledge, neither him nor NCAC are involved. The chairman then adopts confess and avoid posture to discredit the mission by conceding that Kinyua indeed called him, but to discuss assumption of office. We know that assumption of office is a process which is statutory, and members of that office had been appointed and are known and are not members of NSAC or persons who went to see him. Further, it could have been stated in the midst of ongoing tension that the NSAC is sending a delegation to discuss assumption of office when the whole country was waiting and tensions were rising, and in fact there was almost a breakdown at Bomas as these things were going on. The mission was led by Kennedy Kihara, who was the only person who addressed the chairman. The other members didn't speak, and the other commissioners of the other commissioners of IBC of NCSAC, Mr. Kennedy Kihara and the mission was led by Kennedy Kihara, who was the only person who addressed the chairman, and the other commissioners of IBC. Mr. Kennedy Kihara, in his affidavit sworn on 28 February 2022, equally confirms that his whole presentation was to express the need to expedite the process of declaring the results and ensuring transparency in order to avert public anxiety. But the attitude of the chairman is exhibited by the contempt by which he treated this team. They were not met when they came. They managed to find where to wait, but they were kept waiting for 4 hours. Members of a security team in the midst of an election where tension was rising. Having led them, the chairman claims that Mr. Kihara proceeded to caution him, among others, that if IEBC declared the results with Honorable Ruto as the president-elect, chaos would erupt, and that the blood of dead Kenyans will be in their hands. But at this time, they were meeting not in the presence of Mr. Kihara and the chairman. They were all contingent of commissioners and the team from the security, who comprised 4 other people. And he is trying to allege that an executive, a top executive of government, would have gone and made this declaration in the presence of all these people. This claim is, of course, denied. Mr. Kenywa, as you know, is a top civil servant, is a top professional, and we all know that in civil service, discretion is the promise of valor. I mean, in fact, they are so discreet that even in normal things, they would not dare have the public know it. Curiously, the chairman reported the events which unfolded at the Tallying Center on 15th August to the police, and they filed both an OB and also made a statement. There was no mention at all of this heinous act. There's also not any mention of the visit in any of the numerous statements the chairman made. As is common in the divided house of IEBC, the chairman was supported by two commissioners who incidentally also went to the police and made their statements, and both also filed an OB, no mention of this incident. On the other hand, the four dissenting commissioners have filed an affidavit dated 28th August, which confirms on behalf of ourselves and three others that the meeting indeed took place, and what was discussed was issues of security, as was indicated by Mr. Keara. The allegations made by the chairman are extremely grave and have irretrievably sullied the conduct of the official concerned, and indeed, if proven, can constitute an offense under Section 12 of the Election Act. The court views such allegations with great gravity. It has been the position of this honorable court that where an election offense is alleged, the evidence should be clear, cogent, certain, and the proof of which the law commands to be beyond reasonable doubt. It cannot be based on allegation on one side, on a team which is known to be divided, each part supporting its position, and on allegations of the chairman without any further proof when he had had an opportunity to indicate what happened and failed to do so. In the result, it is my humble submission that the allegation made cannot fly. All the chairman is doing is sullying the character of other people to augment his claim for higher principle and integrity. And at the end of it, nothing comes out of the allegation. Indeed, after that, they proceeded, considered the results which were not ready as at the time this team was there, and announced the result he wanted to announce. Suffice is to say that this team, having met them and being satisfied that the results were being declared, made a statement to the whole country telling them to keep in peace and that all things were okay. And you will find that statement made on 16th in the affidavit of Mr. Kenywa. The next issue the Attorney General wishes to address is framed as issue number 6, and that is direction of this Honorable Court on queries whether IBC carried out verification, tallying and declaration of results in accordance with Article 138(3)(c) and Article 138(10) of the Constitution. It is the contention of the Attorney General that the interpretation of the said article is a matter of public interest without going to the application of the article to the dispute before you. The parties have made submissions in connection with the above matter and will not try to take your time by repeating submissions already on record. In this respect, I adopt fully the submissions by Attorney General dated 28th August 2022. The starting point, however, are the two provisions which on the face of it have no ambiguity. They are clear and unambiguous. The Commission is established under Article 88 of the Constitution. Article 250 provides its composition as consisting of at least 3 but not less more than 9 members. Article 253 establishes the composition of each of the independent commission, and Article 253 provides its incorporation. Now, there has been interpretation both by this court and by the Court of Appeal as to what Article 138 it means. And in that respect, I would like to refer you to the case of Raila versus Electoral Commission, and that is the second petition of 2007, and at page 1 and 2. It is starts at page 153. At page 153, this Honorable Court referred to the case of Maina Kiai, and in it stated as follows. Clearly, at paragraph 263, clearly this provision in mind, the Court of Appeal in Maina Kiai decision was categorical as it rendered itself thus: we are satisfied that this elaborate system, the electronic transmission of the already tabulated results from the polling station contained in the prescribed form, is a critical way of safeguarding the accuracy of the outcome of elections. I do not see how the appellant or any of its officers can vary or even purport to verify those results. Further, the Court of Appeal stated thus, and this is the important one: the appellant, as opposed to his chairperson, upon receipt of prescribed forms containing tabulated results for election of the president electronically, transmitted to it from the near 40,000 polling stations, is required to tally and verify the results. The appellant as opposed to its chairman. Later in the ruling, the court stated that it was further argued, that is paragraph 293, it was further argued in court by a number of counsel for the first, second, that disregarding Form 34As and exclusively relying on Form 34B, many of whose authenticity would later be called into question in the tallying process, the said resolution was simply complying with the Court of Appeal in Maina Kiai. We have already held that we find later or nothing in this decision to suggest that by deciding the way it did, the appellate court restrained or barred first respondent from verifying the results from the before declaring them, or that was relieving the former from statutory duty of electronically transmitting the result. What the second respondent was barred from doing by the Court of Appeal and the High Court was to vary, alter, or change the results relayed to National Tallying Center from the polling stations and constituency tallying center under the guise of verifying. So here, when they say what the second respondent was barred from doing, they are referring to the chairman. And it seems to imply that the verification ought to be done by the chairman, whereas the court also quoted with approval the finding in Maina Kiai to the extent that the appellant, as opposed to his chairperson, upon the receipt of prescribed form containing tabulated results of election of president electronically transmitted, is required to tally and verify them. The Maina Kiai decision is expressly clear on the issue, and it states at page, I think it is page 104 of our list of authorities, authority number 3, in Attorney General's Case Digest and Bundle of Authorities, page 67 to 107. It says that we hold further that reference to the appellant in sub-article 3C is not to be construed to mean the chairperson, but rather the returning officers who are mandated after counting the votes in the polling station to tally and verify the count and declare the result, The appellant, as opposed to its chairperson upon receipt, of prescribed form containing tabulated results of the election of president electronically transmitted to it from the near 40,000 station, is required to tally and verify the results received at the National Tallying Center without interfering with the figures and detailed process. In Article 138.10, the chairperson then declares the result of the presidential election and delivers a written notification of the result to the Chief Justice and to the incumbent president. That is now circumscribe and narrow the role of chairperson of the appellant. So it is clear from that according to Maina Kiai, the role of the chairman was to declare the results, and the role of the IEBC was to tally and verify. And that is indeed consistent with the expectation of Article 10, our national principles and national values. So we humbly request this court to take this opportunity to clarify the position without, I think we need to emphasize, and based on what Justice Lena Ola was raising yesterday, the issue of prospectivity and retrospectivity. We're not going to that as the Office of the Attorney General. The Office of the Attorney General wants a clarification of this provision for future election and on how it impacts on other commissions. Is executive role conferred on the chairman, or the chairman is part of the commission and can only act in community with the commission? And that is consistent also with the provisions of the amendments which were done, some of the amendments which were done in 2017. You will notice that the commission has clearly delegated functions to the returning officers. Section 39(1)(a), that deals with National Assembly and County Assembly for them to tally and verify and declare. And 39(1)(b) deals with the right of the returning officers to tally, verify and declare the governor, senator and county women assemblies. But the provision purported to confer the right on the chairman to deal with presidential elections, and that Maina Kiai was very categorical that it was contrary to the provision of the Constitution, and this is what they said. They said that the controversial regulations 83.2 and 87.2 were not affected by amendments, and the object is not difficult to see. The High Court, having found those regulations, that's at page 105, to be inconsistent with the Constitution, it was in bad faith for the appellant to reenact them while pursuing this appeal. It is our firm position that the purpose for which Section 39(2) and 3 of the Act and Regulations 83.2 and 87.2c were promulgated or made have the effect of infringing constitutional principles of transparency, impartiality, neutrality, efficiency, accuracy, and accountability. So that was the position of Maina Kiai. Maina Kiai came to this court. The appeal didn't succeed, and therefore it has impliedly been confirmed by this court. So we humbly request your lordships to take this opportunity, and my ladies, to take this opportunity to clarify that position. To go back, in conclusion, to the members of the NSAC, Lord, I would like to humbly submit that these are Kenyans of integrity, highly professional, who have pulled themselves with their bootstraps and reached the echelon of our system, and it would be very unfortunate when it is left for their name to be sullied in the midst of a political context in which they have no interest. In fact, they were merely asked by the NSAC to send a message. A spokesman was appointed who went and sent the message. But they are now being tarred with the brush of having been trying to unconstitutionally alter a process which is sacrosanct and which they have sworn by their oath to protect in assuming their position. That's my humble submission, and I will donate the 3 minutes to the court. Thank you.
Thank you very much. The 3 minutes and 16 seconds are welcome.
Thank you.
Yes. Mr. Ngatia?
Thank you, Madam President. Please first allow me to introduce the lawyers who have burned midnight hours to present so many affidavits before you. My name is Ngatia Frederick. I'm assisted by the following lawyers: Mr. Kirago Kimani, Senior Counsel; Mr. Kioko Kilukumi, Senior Counsel; Professor Kithuri Kindiki; Mr. Katwa Kigen; Dr. Muthomi Thionkulu; Dr. Linda Musumba; Professor Kivuva Kibwana; Mr. Elias Mutuma; Melissa Ngania, who I had the opportunity to present a matter in 2017 with her; Mr. Mwanza Ombati; Mr. Kipchumba Mokomen; Mr. Benson Milimo; Mr. Wilfred Nyamo Mati; Mr. Edward Mureu; Mr. Hilary Sigei; Madam Monica Nyogutu; Mr. Collins Kiprono; Wanjiko Nyaga; Emmanuel Kibet; Ian Shelela; Caroline Cherono; and Chris Ayeko. Most of them are in court number 1, following the proceedings very intently. Madam Chief Justice, I rise before you. I know it's been 2 long days. Please bear with us to oppose the petition filed by several petitioners. It is the first time in the history of this country that we now have 8 petitions. It must be a new strategy to disable the president-elect to mount a defense against 8 petitions within 4 days. But we didn't manage the impossible, and we now present our defense as follows. First and foremost, my lords, let us appreciate that these consolidated petitions arise from a presidential electoral contest. It is an electoral contest. Ideally situated, or it should ideally be resolved by electorate, the Kenyan voters, not by a court of law. But because it is also part of the constitutional structure of this country, this honorable court is granted original jurisdiction by the Constitution to resolve this contest. But in resolving this contest, it is necessary to bear in mind that all you have are affidavits filed by the contestants. The difficulty with affidavits is that one can structure fiction and peddle it as a pleading, as I'll be demonstrating. I will start with Article 38 of the Constitution, because to me that is the beginning of an understanding of this contest. Article 38 is the one that empowers a Kenyan to vote by secret ballot. And that simple sentence can be broken into three or into two parts. Voting by secret ballot, meaning it confers on the individual power to exercise a freedom of choice, unhindered by anything. Number two, or the second part of it, the vote gives the citizen a power or a badge of dignity for self-actualization. Self-actualization in the sense that a voter is entitled to vote for a candidate of their choice. Article 38, to my understanding, therefore becomes the beginning of the understanding of the correct situation that is before this court. It is common ground, and this is important, my lords, that on 9th August, voting took place everywhere in this republic. There is not a single place that presidential election was not held. Even in Kakamega, Mombasa, presidential elections were indeed held. There is no area in this country that did not participate in that voting. Accordingly, legitimacy, I go to the next point, legitimacy of any electoral victory is predicated on the fact that voting did in fact take place. From Article 38, one then goes to Chapter 7 of the Constitution, from Articles 31, going all the way to Article 81, going to 87, which donates a power to Parliament to legislate on elections. I would immediately say this, Madam Chief Justice. The power to enact Elections Act, to my mind, relates to the 5 other tiers of elections. For the simple reason that for the presidential contest, the inquiry is defined in Article 140. The relief is defined in the same article, whereas in the other levels of elections, one could look at the Elections Act. But I'll come to that a little later. I'm doing first and foremost a broad introduction of the areas that we'll deal with. As I indicated, the scope of inquiry of a presidential contest is defined in Article 140. Before you are 8 petitions. They have mutated. Now they are 7. Oh, very well. Thank you. They have mutated to a large extent, particularly the primary petition. But my request at this early stage is this, that when you retire to consider your judgment, please carry out some surgery, see the mutations which have been added, remove them so that you are left with the original inquiry under Article 140. Why it is necessary to do so is because other things have been infused in this inquiry, like who is to be punished, who is to be castigated. Those are not matters that can be dealt with within the purview, limited purview of Article 140. As a matter of fact, when we argued Raila 1 in 2013, this apex court said a petition under Article 140 should be, I quote, concise, precise, and well-focused. Well-focused. It cannot be a meandering, never-ending saga involving other persons other than the inquiry which is specified in Article 140. As I indicated, since elections were held everywhere, that legitimacy then translates to the following. The people of Kenya did express their sovereign will. They did express that on 9th, and what is now under inquiry is whether that sovereign will by the 14 million Kenyans is to stand unhindered, or whether this court would consider any other remedy other than upholding the sovereign will of the voters. Madam Chief Justice, just barely 2 years ago, Ghana was in the same position that this court is in. They held their elections. A presidential candidate went to the Supreme Court. Identical complaints were made. Complaint number 1, ballot stuffing. Complaint number 2, votes ought to have included rejected votes. Identical with the complaint before you. Complaint number 3, the chair lady was not being fair to the losing candidate. Identical things. And what is now happening in this new space is that we are all getting the drafting skills of our colleagues in other jurisdictions. Dumping and staging, we learned of it in America not too long ago. It is now before you. Ghana 2 years ago had identical complaints with the complaints which are before you. I pause, before I go to the Ghanaian way of resolving this dispute, to acknowledge my good friend, the team leader, Mr. Senior Counsel Orengo. He started by saying his case is not based on conspiracy. And he had to do that disclaimer for a good reason. It is the reason that, other than conspiracy, there is no case. And I'll come back to that in a moment. I go back to Ghana. Ghana considered all the evidence that was adduced, and the Ghanaian Supreme Court came to this conclusion, that the work of the court in a contest of this kind is to look for a substantive truth. I underline the words substantive truth of the elections. Look for the substantive truth of the elections. That's their Ghanaian approach. Then if you look at the you are able to ascertain the substantive truth of the election, then the next very important values, they call them values, is to try to get finality and stability. Substantive truth of the elections. Next layer, finality and stability. Why is there need for finality and stability? The whole purpose of these elections is actually to underscore our democracy, to have a government in place for the next 5 years, and then we'll have yet another round of seeking the voters' validation of who will form government. I emphasize the finality and stability because at the end of this contest, what will be bothering this honorable court, if I dare say so, it is what are the reliefs to be given. Elections are carried out by our good Kenyans. I said in 2013, I repeat it again, we are unable to inculcate amongst ourselves the culture of accepting the electoral result. We are just unable to do that. Maybe it is in our psyche, maybe it's in our makeup, but we are unable to do that. Because we are unable to do that, we must then come to this honorable court to try and resolve that dispute in a very unfair way, because the dispute ought to have been resolved by the electorate. In my submission, when you look at this case, devoid of lawyers' arguments, you find it is based on certain planks. Plank number 1. Form 34A was hijacked mid-air, altered, votes from one candidate, losing candidate petitioner, removed, added to the votes of respondent number 1. That is a major plank of it. The easiest way to look at it, because I do not have the ability of Mr. Mahat, who dealt with technology, is to look at it from a point of logic or the antithesis. The antithesis being this: if that is true, from a point of logic, show us one Form 34A in the public portal, because that is where ultimately it landed, which differs with the hard copy at the polling station. Show us only one. Or show us a ballot box that people from outer space came and voted into, stuffed into it, and then all this hijacking in midair took place. There is no such evidence. And why there is no such evidence is because that is the work of fiction. Work of fiction, not just conspiracy, but work of fiction. In my submission, therefore, amongst the many things this court is now being called upon to do, is to find a way of moderating, I use the word moderating now in the correct sense, the excesses in the political contestants. Excesses such as imagining that this Supreme Court can now take over the role of voters and do a court coronation of any candidate. That would be a heresy. I will be dealing with the reliefs much later. I'm just doing a broad outline. And the next broad outline I would wish to do is to indicate to this honorable court that the orders sought in the primary petition, apart from being contradictory, would take this country to a constitutional crisis. We now have the incumbent in office with the limitations in Article 134. Limitations which are set or cast in stone by the Constitution. The incumbent in office cannot even appoint anybody to take over from any of the public officers being vilified before you. If, for example, and I say for example guardedly, this honorable court were to even countenance anything other than stability and finality, then a constitutional crisis would be triggered because the petitioner has repeatedly said he will not participate in an election held by IEBC under the chairmanship of Shebukati. We have adduced that evidence in the replying affidavit sworn by the first respondent. That replying affidavit is before you. It was filed on 26th August. We have attached a clip of that discussion. It's in an affidavit by Samuel Githae of the same date, 26th August, and all those are matters that are before you. Since the petitioner will not participate in a fresh election, does not want to accept defeat, then what does he offer? What is the solution he offers? The solution he offers is that there be an election presided over by the vice chair lady of IEBC. And only one needs to state that to see the crisis that this country will be engaged in. It will be a crisis of monumental nature, a crisis that I do not think that you would want to play with that kind of fire, because it will be fire upon fire. In my submission, therefore, I would request this Honorable Court, as we begin our submissions, to bear in mind how Ghana resolved an identical situation by, number one, looking for the substantive truth, and then immediately that should trigger a relief which is finality and stability. If this Honorable Court were to do that, I see a future for us. Any other solution, the crisis offered by the petitioner cannot be a crisis that this court can countenance, because your fidelity is not to anybody other than the Constitution. Since your fidelity is to the Constitution, I dare say, then the reliefs that you could consider are the reliefs within the constitutional structure of this republic. With those comments, Madam Chief Justice, allow me to invite the first counsel to present, who is my good friend, Mr. Katwa Kigen. Mr. Katwa Kigen will deal with issues 1, 2, and 3.
May it please Madam President, my ladies, may it please you, my Madam President, my ladies, my lords, my name is Katwa Kigen. I propose to deal with issue number 1, 2, and 3, and may I indicate that in dealing with those 3 issues, I'll be dealing with them together with Dr. Mudomi. My lords and my ladies, the 3 issues are to this effect. The first issue relates to the integrity of the technology, and the wording of that issue is whether the technology deployed by IEBC for the conduct of 2022 general elections met the standards of integrity, verifiability, security, transparency to guarantee accurate and verifiable results. The second issue relates to the question of whether there was interference with transmission, and it is to the effect whether there was interference with the uploading and transmission of Form 34A from the polling stations to the IEBC public portal. And the last issue that we will be dealing with Dr. Mudomi is the question of whether there are differences in Form 34A, and the wording is whether there was a difference between Form 34A uploaded to IBC public portal and the Form 34A received at the National Tally Center and Form 34A issued to the agents at the polling stations. Now, my lords and my ladies, some of the issues that I will be discussing, or rather some of the issues we will be discussing with my learned colleague, are issues that have been discussed, but we must mention them, especially considering what the petitioner in the petition that we are dealing with, the one by Honorable Raila, states at paragraph 35 of his petition. And in that petition, I'm just reading the second sentence of that plea, where he states, the evidence shows that the acts complained of were committed by third parties, senior employees of IBC, acting in connivance with the second respondent in order to achieve a predetermined outcome in favor of the ninth respondent, and the ninth respondent for purposes of this petition is the first respondent. And so we are coming from the position that we maintain and insist that there was nothing that the first respondent did that could be said to have exceeded or to have amounted to collusion with the IBC. And I would like to start my submissions by reference to the issue of Form 34A and what the first respondent and the second respondent did. My lords and my ladies, in Maina Kia it was determined that Form 34A is for all practical purposes cast in stone. What Form 34A contains is the last word in respect to the wishes of the voters in the given polling station. And if it has to be in any way impeached, it is only when it has been brought to court. And so, in recognition of that, the first respondent, as allowed in law, availed his agents at the polling stations to participate and watch over the process of the elections. And we wish to emphasize that the place of agents is a very material part of this petition. It is going to be a very important issue in your determination of this petition, because the bulk of the evidence in respect to the issue of Form 34A in this petition is the allegation by one Arnold Ochieng, an advocate, saying that he received Form 34As which showed that the data in the Form 34A in the public portal, the data in Form 34A that the agents of the petitioners had, and the data in Form 34A that were brought by the returning officers to the National Tally Center were different. And so the question of whether or not there were agents, whether they could be trusted, and so on and so forth is important. But for purposes of the first respondent, we wish to maintain the position that he had agents, and those agents are failed to him Form 34A through his lead agent. And after the Form 34As had been filled at the polling station, and all the agents available had been invited to endorse and confirm that the data captured in the Form 34A were true and accurate. After that had been done, the first copy of the Form 34A was then transmitted to the National Tally Center, the public portal. The other one was then taken to the National Tally Center. Now, I just want to emphasize two issues in that. One is that both the parties for the petitioner and the parties for the first respondent had a chance to participate. The second thing I wish to emphasize, my lords and my ladies, is that in the entirety of the petition, none of the Form 34As at the point of the polling stations have been presented as having been challenged at any point. So that then the irresistible conclusion that should be made from the point at which the Form 34A originates is that those Form 34As represented an accurate state of affairs at the polling station, both in terms of data and in terms of the integrity of the process of voting and the counting of the votes. And as I said, then the Form 34As find their way to the National Tally Center, both in terms of transmission and the physical delivery by the returning officer. Again, agents for both parties were given a chance, and as allowed in law, the first respondent made sure that he had representation of his agents and has presented some of those agents to vindicate and verify that the data that was eventually verified at the National Tally Center were the accurate data of what happened at the polling station and passed on to the National Tally Center. I would like also to emphasize that the two things that were supposed to be done at the National Tally Center was to determine the data, and secondly, to establish the security features of the Form 34S. Having said that, my lords and my ladies, and considering that especially at issue number 3, your attention is on the propriety and the integrity of Form 34A, I must submit that the petitioners have not adduced any evidence of any challenge of any Form 34A at any point in the national tally. And this is the second chance they have, having had an initial chance at the polling stations. There is none of the Form 34As that have been challenged. It is with this state of affairs then, and as a result of this process, that eventually we have the declarations of the result coming out to indicate that the total votes cast, total valid votes cast were 14,213,027, being a product of a process that was interactive and where all the parties were involved. It is a product of this process also that comes out with the result that the first respondents' total votes were 7,176,141. Now,